the library has to offer. We welcome you to come to the library tomorrow and learn more. So, without further ado, I'm going to turn it over to David Goldberger, who will talk about his role in one of the most significant events in Skokie history.
Well, let me say hello to everybody. I'm happy to be here. I'm caught a little off guard by the fact that there are unexpectedly, several of my family members here going to supervise the event. But they're welcome anyway. But you can't give me any gas, any of you. You can save it for off camera. Okay. Now, let me tell you a little bit about myself. I'm Jewish. I'm very proud of my heritage. I was born on the north side of Chicago. From ages about 10 to 18, I was raised in the south suburbs of Chicago. I'm a secular rather than a religious Jew. My views are politically liberal. My parents were liberal, but not knee-jerk liberals. And I'm a very, very committed civil libertarian. The ACLU, American Civil Liberties Union of Illinois, was my first job out of law school. I loved the job because of the ACLU's commitment at that time to neutral principles of civil rights and civil liberties, especially the First Amendment. And by neutral principles, I mean that the same rights are for all people under the Constitution, no matter who they are or what they believe, and that the ACLU would represent people without regard to who they are or what they believe, so long as their rights were being violated under the Constitution or under the civil rights laws of the United States, irrespective of their identities. I was the ACLU legal director at the time of this case. And the National Socialist Party of America and Frank Collin had been, at the time, was my client in cases in Chicago, and then became my client and the ACLU's client in the Skokie case. And I mean, the truth of the matter about the Skokie case is that it really originated on the southwest side of Chicago, in the sense that this group, the NSPA, wanted to hold public assemblies, and did on one or two occasions, in Marquette Park, which was on the southwest side of Chicago. But the city of Chicago, under the original Mayor Daley, not the one that probably most of you are contemporary with, was going to block their access to every park in the city of Chicago, no matter what. And when that happened, the NSPA came to the ACLU and asked for representation. And needless to say, that was the beginning of, the beginning of a pattern that we didn't have people that wanted to step forward and volunteer to provide that representation. So I, as the legal director, undertook it, and did so because they were being blocked from the Chicago parks because they wanted to exercise their rights to freedom of speech just like anybody else could at the parks, and they were being singled out solely because of their identity and their views. And so what happened, and this may be old news to all of you, some of you, many of you, is that, at least from, as the client told me, once they were blocked from the Chicago parks, and we filed suit to get them back into the parks, but it got basically tied up in the federal courts, they began to write letters requesting permits from to speak in the park districts in the various parks in the Chicago suburbs. And at least according to the client, and I have no way to verify this or never did verify it, Skokie was the only one that responded to the NSPA letter. And Skokie said flatly no. And at least they, as I recall, the National Socialist Party applied to the Skokie Park District, and the Park District said no. At which point, the NSPA and Frank Collin announced that they were going to demonstrate by picketing in front of the city hall or the village hall. And, and the signs were going to say free speech for white people, white free speech. But they were going to appear with their swastika flag and wearing the uniforms of Nazi soldiers and with swastika armbands. Well, I got a call. Basically, I think the call came in at home because I was listed, and I represented them in a case against the Chicago Park District, and I got a call, and they said they just served us with an injunction, and we need a representation. And I must have called a half dozen ACLU lawyers to ask them, these were volunteer attorneys, if they would undertake the case, because it was the next morning. And the response was, sorry, call me about something else, and please do it later. And frankly, a couple of them simply said, look, I can't do this because my firm would never approve of it. And I just don't have the stomach for it. So, to make a long story short, I appeared with my co-counsel, Barbara O'Toole, and we were off and running the next morning in court. The reason the ACLU was involved, the reason that I was involved, was that it really raised classic First Amendment rights and First Amendment constitutional issues. And I'm gonna, I've been invited, and I'm gonna be in a moment take you a little bit into the First Amendment weeds, but I first want to comment. It was no surprise that a no came from Skokie, because at the time there was a very large number of Holocaust survivors that resided in Skokie, and some said the largest number of camp survivors in one community. I don't know whether that's true, but and at the time, I think Skokie was 40%. I was told that it was about 40% Jewish. I don't know if those figures were accurate. I was later told it was 25%, but that really doesn't make any difference. In any case, the turn down was no surprise. But then Skokie, I skipped a step. Skokie announced that they were going to, no, I didn't. Skokie announced that they were going to picket in front of the village hall, and they were served with an injunction suit. And what it sought primarily, which really kind of raised the First Amendment stakes enormously, is they wanted, and here we go into the weeds, they wanted a prior restraint on speech. That is, that an injunction against speech which prevents it from happening, as opposed to subsequent punishment where someone makes a statement that violates the law and they get prosecuted. And basic First Amendment principles are in this country: first, prior restraints, injunctions against speech, are presumptively unconstitutional. That is, that there's a very heavy burden of proof on the government to justify a prosecution, or I beg your pardon, to justify an injunction against speech. And so we were off and running. Of course, Skokie raised two other critically important issues. They wanted to prevent hate speech, and they simply wanted to protect the community against having to deal with the Nazis at all. And the obvious question was, should this kind of speech be protected? Well, the issue of prior restraint, that was a no-brainer, because there was a case in which there was a document known as the Pentagon Papers, which was a set of secret documents basically explaining the reason for the American involvement in Vietnam, that a government employee had copied and sent to the New York Times and the Washington Post and so forth. And the Supreme Court refused to allow an injunction against publication basically on the ground that it was a prior restraint on speech, that if it was illegal, the newspapers could be prosecuted after the fact. And the government failed to prove up front enough proof that there was a security threat posed by the Pentagon Papers to justify a prior restraint. Now, where the Nazis were involved or concerned, Skokie had the additional option of trying to prove that that this village of Skokie could not restrain the crowd, and that there would be, they couldn't protect the speakers, basically. And therefore, there was a clear and present danger of turmoil and violence, not because of what the speaker was doing or saying, but because of an angry crowd. Now, the village of Skokie never really relied on that ground, because as Harvey Schwartz, the village's lawyer, told me, he said, we simply do not want to say that our police are not up to the job, so we're not going to take that position. And so the only justification that they had was that there was hate speech. And again, under the First Amendment, and this may be hard for all of you, it's not fun, but hate speech is protected by the First Amendment, so long as it's not addressed to an individual. In other words, if I call you a dirty name, that's hate speech, or a form of hate speech, because it will trigger what I would say in my briefs is reflexive retaliation. That is, you say it to me and I'll punch you in the nose reflexively. But it was well established that standing alone, a statement to the public that is regarded as hate speech is protected. And the leading case was the case of Cohen versus California, where Mr. Cohen walked into, an anti-war protester, walked into a California courthouse, and on the back of his jacket, it said, F the it was all 4 letters, F the draft. And he walked down the hall, got to a courtroom, took off the jacket, put it over his arm, went into the particular courtroom, came out of the courtroom after a while, put the jacket back on, and he was arrested by the sheriff's deputy on the ground that there was a woman and her child in the area, and therefore it was disorderly conduct. And the Supreme Court said basically, no, it wasn't addressed to anybody. As offensive as it was, it's protected by the First Amendment. And the only exception, as I just explained, would be if it were addressed to you as an individual, so that you would reflexively want to punch the guy in the face or something of that nature. It doesn't have to be that there's a punch thrown. In the case, the person made a face-to-face communication with a police officer, which was court found sufficiently offensive face-to-face to justify the conviction. Now, why is such hate speech protected? And the answer to that is that it's defined by its offensiveness to the listener and to the sensitivities of the audience. Examples would be abortionists or murderers. And it depends on who you are. For example, if you say to some people, there are only two genders and there's no such thing as a transgender person, then some people would regard that as hate speech, and other people would regard it as political communication. Same thing could be said about the statement, anyone who denies there's white privilege is a racist. Or your denial even of that there's white privilege makes you a racist. Is that hate speech, or is it simply offensive communication? It depends on the viewpoint, or is it none of the above? And that depends on the viewpoint of the audience, and so forth. So that was the guts of what happened. We went to the courts. We lost in the state courts up until the Illinois Supreme Court, and they agreed with us. I'm really cutting to the chase. There was a lot that happened in between. The federal courts took the same position when Skokie passed ordinances or tried to pass. You've got someone in your waiting room, I think. When Skokie tried to pass ordinances or passed ordinances which would do the same thing the injunction tried to do, and the federal courts threw that out, and it went to the Supreme Court, and the Supreme Court refused to overturn, although they didn't rule directly on it. They simply let stand the lower court opinions that threw out those ordinances. So that I think that gives you kind of a rough idea of what happened in the Skokie case. I was treated with dignity and fairness by the Skokie lawyers and by the Skokie public officials whenever I dealt with them face to face. And I have in retrospect, no regrets for what I did. I understand that it's hard, and I suspect that there are some folks here today that are uncomfortable with the decision to provide the representation. The one thing I'll say that I'm pleased about is that I think in the long run, the Skokie case, I think, now somebody can correct me if I'm wrong, and Rachel, you surely can do it, but that without that case, the Holocaust Museum in Skokie probably never would have been built. And so if there are any questions or comments, I'm open to them. You want to take it from there?
Yeah, that's fantastic. Okay, so I am first going to Okay, so I just changed the settings right now so that people can unmute themselves if they so desire. If you have a question, I would love it if you could use the little hand raisey reaction on the bottom of your screen to jump in and say that you would like to ask that question. And I will look to my co-hosts potentially to help me stay on top of that, because sometimes it's hard to look at both the chat and at the waiting room and at the list of participants. So I do see a couple of hands raised, which is great, and I'm going to start with a question that came to me in the chat, which is, do you think that the ACLU would take this case or a similar one today?
That raises a whole different opens a whole different can of worms. I think the ACLU has kind of lost its way when it comes to freedom of speech, because their position now is, who are you, and do we feel good enough about your speech that we're willing to represent you? That's an overstatement. It's not exactly fair to them, but I don't think they'd take the case today. However, in response to that problem with the ACLU, an organization has emerged called the Foundation for Individual Rights and Expression. It's called FIRE. And they're taking those cases now, although they're much smaller and they don't have the kind of resources that the ACLU does. So that the ACLU has kind of developed an orientation toward progressive politics that I think is unfortunate. I think it should be more politically neutral, because I believe in neutral principles.
Okay. Next up, I'm gonna call on Dan, if you want to go ahead and unmute yourself and ask your question.
Sure. Thank you. This is Dan Montgomery. I'm a former English teacher at Niles North, taught there for many years, president of the State Teachers Union now. David, great presentation and fascinating to hear from you. I'm curious, at the time, given what you were explaining about the Pentagon Papers and the court's position on prior restraint, is it true? Was it the case that the lawyers in the city of Skokie kind of knew that they would lose, but they felt because of their citizenry they had to take this position? Or was it your understanding that they really thought they could win this argument and prevent them from marching?
Dan, that's a really good question. Historically, what happened was that the lawyers from the village of Skokie advised the city council and the basically the mayor of Skokie that the best thing to do in light of the legal situation was to tell people to stay home and ignore them. They would be gone in a half hour or less, and it would be over. And the community felt that was impossible. So I think that the village attorneys felt they had no choice but to file the lawsuit as a political matter. But then they passed the ordinances, which they thought had a better chance of being sustained. But I didn't, at the time when we saw them, I thought they wouldn't stand up either, and they didn't.
Thank you for that answer. If I could just follow up, what did the ordinance actually say? How did they try to prevent them from marching?
You can't appear in military style uniforms. You can't display the swastika.
I see. Okay.
And so forth. I can't. I don't. I'd have to dig back into my files
that makes it clear that it was
the ordinances.
Yeah, that's helpful. Okay, thanks so much.
Okay, so I'm gonna send it off to Esther. Your hand is up, and you were second.
my question was if when you were representing them or when you just like were working with them at all, if they ever found you out you were Jewish, did they treat you any differently?
To be blunt, not to my face, because we were the only show in town. If they treated us differently, or were offensive or did not act appropriately to be as a client should act, I was out of there, and they knew it. And I will tell you the truth that there's a book called when the Nazis came to Skokie by Philippa Strum, which she says that the leader of the group, his father was a Holocaust survivor.
Wow.
So,
And I see Jessica holding it up. I'm sure that this is a book that you can get at the Skokie Public Library for a checkout, as well as we probably have a reference copy. So I got a request in the chat for from Griffin. Griffin, if you want to go ahead and unmute and ask your question.
Hello, and apologies for any background noise I might have right now. Mr. Goldberger, in light, do you see any potential future cases like the Skokie case coming up in the new Donald Trump administration, or any threats to freedom of speech with a new president?
we don't have enough time to really give a complete answer to that question. What happened in Charlottesville, Virginia, to me was substantially similar to the Skokie case. The difference being, and that makes it, as a lawyer, it makes it emotionally a tougher call, and that is that since then, since the late 70s, 1970s, the white nationalist movement has become better organized and much larger. And so I can see things like that happening, but in light of the pardons that we saw within the last couple of days, there's nothing in the federal government that's going on that would, in my view, seek to restrain neo-Nazis. As Trump said, there are good people on all sides, or both sides. We've got a whole new set of problems in the current generation.
Okay, Josie, you had your hand up the next longest. If you want to go ahead and unmute yourself.
Hi. You said at the end that after the Nazis marched, they'd also kind of like pushed Skokie to build the Holocaust Museum. Would you say that that the allowance of the Nazi march could have been beneficial to actually the Jewish cause in that way, as it brought more attention and allowed and like gave a further push for like the Holocaust remembrance?
I think that's a judgment that you need to, everyone needs to decide for themselves. And I don't think a Nazi march is a particularly good thing at any time or any place, but the Holocaust Museum is a good thing. I don't know how you put those two things together. I think it's a tough question, but I think every person's got to decide for themselves.
Okay, thank you. Sorry.
Okay, awesome. So the next question came from the chat. And the question was, how would the situation play out if the neo-Nazi gatherings were to occur in a different village/city? And I know that's maybe a little bit similar to your answer about Charlottesville, but if you want to sort of expound on that.
I think it's an easier case when you start to move to a place like Charlottesville. The thing that was very problematic in Skokie from the point of view of judiciary, I think, as well as emotionally for the people that were involved, is that you had such a large concentration of Holocaust survivors and camp survivors in one place, in a fairly small community. Charlottesville was, by comparison, bigger, and the demonstration was about a statue, as I recall, and not about and couldn't be interpreted as an attack on a group. And I mean, there was a whole other issue in here which we've not talked about, which really gets deeply into the weeds, which was Village was saying that this is group libel, essentially, that your hate speech in this particular case, the display of swastika, libels Jews as a group. And the courts said that group libel was no longer a valid constitutional doctrine, that in fact Illinois had a statute on its books that prohibited group libel, but it repealed that statute years before the Skokie case, so that that would be as close as you could get to it, but there was nothing like that in Charlottesville, and I don't see that happening in many communities. That set of circumstances was pretty narrow and focused.
Okay, so Noah, if you would like to take yourself off mute, you're up.
I was just wondering, Mr. Goldberger mentioned that if Nazis had treated him with something less than the respect between a client and an attorney, that he would have dropped them as his clients. And I was wondering why in particular was that the line that if free speech is so important, if freedom of speech is such an important matter of principle, why is a direct insult to you the hard line in the sand, so to speak?
That's a fair question. My simple answer is that in order for a lawyer to represent a client, the lawyer has to feel that that lawyer can be objective in his or her representation. And if the client is attacking the lawyer, and this is a particular problem, it wasn't a problem that I had in this case, but some of the cases at times you'll see in criminal cases where you've got a really crazy client who has been appointed to as a public had a public defender appointed to defend that individual, and the client starts to attack the public defender. When it becomes personal, the lawyer can't be sure that he can remain objective and present the case objectively. And that was my view. If I were personally attacked, then there would be animosity toward the client, and I couldn't trust my own judgment to represent that client effectively, which is my duty as a lawyer.
Thank you.
If there are no other questions, I've got a question to my sister.
We do have we have more questions in the chat, but we'll put
She's
in
running.
that one. So we had two questions that were related. One was, how did representing the Nazi Party affect you personally or with your family? And then a follow-up question about what effect did taking this case have on your future career, if any?
Well, in terms of my family, I don't think I ever really discussed the case with my sister until afterwards. Um, but I was in touch with my mom and dad about it, and my dad was proud, and my mother was silent. And she would always say to me, not in this case, she would say, blood is thicker than water. So I never doubted that I would have her support. So within my family, and there was, my extended family, I think for the most part, understood my position. My Uncle Louis had a hard time with it, but he once reported to me, he was out in New York in the garment industry, somebody said, did you hear about that crazy guy that crazy Jew that's representing the Nazis? And my Uncle Louis said, that's no crazy Jew, that's my nephew. So, and that was the end of it. But I think some of my family had a hard time with it. But again, they knew me, and they knew that I had no sympathies with the client. I mean, one really tremendous insult that really infuriated me is that the Anti-Defamation League became involved on the other side, filing its own separate lawsuit to try to block the assembly. And they referred to me in the brief in one of their memoranda as neo-Nazi counsel. And I reported that to the national executive director, who reported it on to and raised, frankly, excuse my French, raised hell with the national office of the Anti-Defamation League, and I got an apology.
Okay, so next question is, how did this case affect the way government/police can respond to such protests or requests for demonstrations?
That's a fair question. I can't tell you for sure. I felt that even though the Supreme Court never ruled on the merits, we went in the Supreme Court to force the Illinois courts to rule because they were stalling. It was too hot to handle for them. But I felt, and I still feel today, that it was a teaching tool and remains a teaching tool about where the parameters of the First Amendment are in the United States. Because unlike the United States, for example, the same group with the same speech could be shut down in England, France, Germany, and so forth, and jailed. In fact, in Germany, a man was thrown into jail, a historian, kind of in quotes historian, a Holocaust denier, published a book denying that the Holocaust ever occurred, and he was given a 2-year sentence in jail, and that could never happen in the United States. So that, like I said, I think Skokie kind of made that clear, and I'm pleased that it did, because I believe freedom of speech, even the ugliest speech, is very important. Because what's ugly to me is not necessarily ugly to you.
Okay, next question. If the village of Skokie had won the case, do you believe that it would have set a bad precedent for the future of American democracy and Americans' rights to free speech?
Absolutely. Otherwise, You know, otherwise I I don't think I could have done it without that belief that it would have been a terrible precedent, to be able to shut up this particular First Amendment activity. It was peaceable, and the offensive communication in Skokie was the appearance of the swastika and the uniform, but and the group, I suppose, by its identity. But the speech itself, free speech for white people, white free speech, at least that was what the client um, said on the stand was going to be communicated. That was about as offensive as it got. And if that could be enjoined, what else could be enjoined?
Okay, so this one is, since the whole incident happened because Chicago didn't allow the Nazis to use their parks, why didn't they want to march in the city from the beginning? Why did they involve Skokie?
Well, you know, what they said, and all I can tell you is what the client said, is that they tried all different venues because they were being shut, their main venues were shut to them. So they had to go to some place to communicate their views. And they said that they had basically papered the suburbs with permit requests or notifications that they were going to come to speak, and they got no response except from the village of Skokie. Whether that's true on the facts, it never became clear one way or the other. So we had the client's word, and that was the only information in the record. They made it sound like it was chance. I have my doubts.
Okay, so we had a follow-up about Charlottesville, and the question is it your opinion that Charlottesville would actually be easier to defend in court as an act of free speech than the Skokie case?
Well, going in, it was. I mean, remember, one of the reasons we're looking at Charlottesville in such horror is as things got more intense, jackass drove his car into the crowd and killed somebody. And I think that's kind of drove home a very special problem that was posed by Charlottesville. In addition, the police didn't know what they were doing in Charlottesville. If you ever, I think it's online, there's a report, very lengthy report on what happened in Charlottesville that was done at the request of the city by an outside law firm. And it turned out that the police, there were, I think, 2 or 3 different police operations. They were not communicating with each other. There was dilly-dallying about how to handle it. The chief of police said, "Oh, it's no big deal. If we ignore it, it'll go away." So it was just mishandled from beginning to end. That the village of Skokie and the suburban police departments, as well as the city of Chicago, knew exactly what was going on at all times, and I think they were in communication with one another. So it was none of this kind of Alphonse Gaston, if you recognize that reference in baseball, where you watch 2 guys can't figure out who's going to catch the fly ball and it falls between them. It was none of that in Skokie.
Okay, so this question, I suspect the answer is yes, so feel free to extrapolate. Was this the most controversial case you ever did? And if not, what was?
Listen, This case happened in the late 1970s, and it's here 2025 that we're talking about it. No case that I ever dealt with had legs like that. And I dealt with some controversial cases, including one in which the U.S. attorney wanted to refer, or not the, an assistant U.S. attorney referred me to the FBI for investigation because he thought I was fighting too hard in a case and I was cheating, and I wasn't. But nothing like this. I wouldn't wish this case on a dog, frankly. It's not one you go hunting for, let me tell you. It's almost like being in an automobile accident. You know, you just find yourself there and it's an, oh my God. I still have a question that I'd love my sister to answer.
Okay, let me get this. I think I have one more question,
Right.
and then we'll turn it over to you.
I can't resist.
So this question is, what advice would you give to students on a college campus who might object to a speaker whose views they disagree with? And what would be the best way to register their disapproval?
Well, I mean, some of this has to do with what the rules of free speech are on the particular campuses. But my view is you protest peacefully and non-disruptively as you can. Do it as peacefully and as non-disruptively as you can, but protest. I don't believe that you should go home and sit quietly. I think that the best response to offensive speech or speech you disagree with is counter speech, but according to the rules of the game, not to try to disrupt it.
Okay, we got two more questions, but do you want to ask the question that you have of your sister before we
Sure,
go on?
if they'd unmute. Can you unmute, David? There we go. Just what was it like at home? I think, were you in the house at the time that I was going through this, Ruth?
I think I was already living in an apartment.
Okay, so you didn't have to. You
What year? What was the year?
1977 to 79.
Yeah, I was married.
Okay, so, but did you have any sense of what was going on with mom and dad and what they were having to put up with?
Well, I think
you had to put up with.
I think all of us felt not any disagreement with what you were doing, but very protective of you because you were getting threats. It was so hard. It was, you were getting, I remember the reaction of our rabbi. I mean, it was so difficult that we were protective of you. And I know at one point I said, are you sure you want to continue with this? And of course you said, yes, I have to. And that's how it was, I think, with mom and dad. I don't think they ever disagreed with what you were doing, but it was just hard to watch.
Okay, you said, Rachel, that there was another question. Thanks a lot. So I apologize for putting you on the spot, at least apologizing a little.
Okay, yeah, we do. We still have we have two questions that I see right now. So the first is, what is your view on online free speech? There is ongoing discourse regarding online platforms acting as a publisher or forum. What is the role of online platforms moderating speech?
I may be an outlier on this one. My view is that the platforms, Facebook and so forth, are private platforms. The First Amendment protects against government interference with speech, so that Facebook and X and the rest of them are not interfering with the right of freedom of speech in any constitutionally significant way. They're more like newspapers that are publishing. And although they're not exactly like newspapers that are publishing, I concede, but I think it would be a bad thing for the government to be in there regulating and forcing them to say things or not say things as part of its power. I think that, so contrary to all the yelling and screaming that they're violating First Amendment rights by interjecting their views as to whether a statement is false, or even when little Lord Fauntleroy, Musk, stops people from making criticisms of him on his platform X. They're not violating, in my view, they're not violating any rights to freedom of speech. Maybe they shouldn't do it because it's ethically wrong, but that's a whole other question.
So I'm reading the other question that I got, and it's actually related. So I'll read out the whole question, and you can, I think that you've already responded to part of it, but do you have an opinion on the free speech argument being applied to social media? Social media platforms have the right to exercise their First Amendment rights editorially, yet the stakes of their editorial decisions are only growing. Do you believe that First Amendment law as it applies to the real world will eventually cross over to the internet, and should it? And then finally she says, thank you for your time on behalf of the Skokie Heritage Museum.
That's a tough, I mean, there are several questions wrapped up into that. The really tough question, and I don't have an answer, and I'm going to kind of waffle on this a lot, and that is that there are different standards right now, First Amendment standards applicable to broadcast media, for example. There are certain things that you can be denied a broadcast license if you're using obscene language that is, four-letter words and things like that during hours when children might be listening. And the Supreme Court has said, yes, you can basically discipline or threaten a license of a broadcaster who broadcasts something that is really, truly what's profane with regard to children. So that it's possible now that the Supreme Court will eventually take a position that's somewhat less protective of the internet media than other media. But I would be uncomfortable with it, but I understand it. I mean, the tricky thing is that there's a federal statute right now which protects the I'm grasping for the word, but essentially the internet providers from suit for libel, and that would include Facebook, for example. When someone posts a libelous statement on Facebook, you can't sue Facebook right now under a federal statute, unless, of course, Facebook is responsible because it's uttered the libel. But a mere posting of a libelous statement is protected. The only person you can sue right now is the person that posted it, and of course that's a problem because you have so much anonymous speech on the internet. And the one way that the government can crack down, which is what Facebook right now, why I think the owner of Facebook, or the chief owner of Facebook, is kissing up to President Trump, is that he's worried that statute might be repealed. And that would be a way that you might affect the First Amendment rights on the internet, because essentially there's no First Amendment right to say something libelous about somebody else. That's a unprotected speech, just like obscenity is unprotected. So it's a pretty tricky area, and I have misgivings about it because there's so much anonymous speech, and there's so much false speech on the internet right now. But a false statement which doesn't libel you is constitutionally protected.
Okay. So first I just want to say we're at 7:30. If folks need to go, like, please, you are welcome to. And those of you who are able to stick around, we do have a couple more questions, and I'm very grateful to you, David, for continuing to engage. So we have a question: how does the idea of yelling fire in a crowded building apply to these ideas of free speech? How can we protect free speech and access to accurate information, especially here in Skokie?
Well, let's take those questions one at a time. First of all, the fire in the classic example is falsely crying fire in a crowded theater, because what that does is it essentially misleads people in a way that can cause them harm. And that is not protected. That creates a so-called clear and present danger of physical harm. Now, the other question, the other point, you're going to have to remind me of what it is, the rest of that question.
How can we protect free speech and access to accurate information, especially here in Skokie?
Right now, I don't have an answer to that. The only thing that I can say is more speech. Yeah, the best tool that we have is more speech and more information. Unfortunately, what's driving me crazy is it's not adequate to rebut some of the ridiculous falsehoods that are floating around. For example, that, excuse me if you disagree with me, but that vaccines cause autism, for example. I don't know what you do about that kind of nonsense, because people latch onto it and won't let go. And we've got a guy that's now going to be, in the president's cabinet, who's uttering those kinds of falsehoods. I don't know where you go with that stuff. I have no answer.
Yeah, that's fair. Okay, and then the last question that I have here in the chat is, have you written a book or diary about your experience in the Skokie case or other cases with the ACLU over the years?
I have a draft of a letter to my children that they've never seen or probably never heard about before. And it's been sitting on my computer for 1.5 or 2 years. It's not for publication. There is an unpublished chapter of that's supposed to come out as part of a collection with the Oxford University Press, but it's been in the pipeline for 2 or 3 years at this point. And you folks, I think someone on your staff, or you did, Rachel, somebody told me they thought it was coming out at some point. I'm beginning to have my doubts. And if I can get that cleared from them, then I'll send it to you and you can post it someplace publicly.
Yeah, that's that was Jessica, our digital collections librarian. So and Jessica, if you want to take a minute to talk a little bit about how people might learn more if they're inspired. I can drop a couple links in the chat if you want, but I also invite you if you want to talk a little bit about your collections.
On the link from the library's local history section of the website, there's a digital collection and a digital exhibit about we call it the attempted Nazi March in Skokie. And we were able to, with Harvey Schwartz, get some of the recordings of the board meetings that occurred in the village digitized, and so those are available in that digital collection. The original ordinances, we've scanned them and they're available online. There's also a couple of recordings of video recordings that are available in the resources section, and bibliographies. So, and there is an ACLU of Illinois, I think it was an essay or a blog post that Mr. Goldberger wrote that's on the ACLU page that's linked from there. Yeah, and then once this chapter gets published, we'll make that available as well from the digital collection.
Jessica, if you want to get in touch with the people at Oxford, I will too, to ask them to release it from the copyright, because they're sitting on it. And, I'm happy. It's not very long and not all that unique, so I wouldn't mind having it available.
Super. I'll follow up with you tomorrow.
All right, that's fantastic. So if anybody has any last questions, we'd love to hear from you. And I'll give it another little piece of time. Once again, if you are a middle or high school student and you are hoping to get some service hours and you have not sent me a direct message letting me know, then please do so now, because there are a lot of people in this meeting and I don't know everybody. So if you are a middle or high school student and you want service hours, send me a direct message, please. And if there are no further questions, with no further ado, I'm going to go ahead and end this meeting. And the recording will be posted on our events YouTube page and will be linked to in our digital collection as soon as possible, hopefully within the week. And when that happens, I will send an email out with the link to everyone who registered. So thank you all so much for joining us and have a wonderful night. Stay warm.